Good afternoon. My name is Greg Stark, and I am a principal at Schwegman, Lundberg, and Wissner. SLW is pleased to bring you 10 things to know about the Chinese patent process, presented by Aaron Wininger. Aaron is the director of our China intellectual property practice. Aaron counsels both US and Chinese companies on portfolio development, preparation of patent applications, and office action responses. He has worked with clients in areas of software, networking, lasers, medical devices, semiconductors, and physics. Aaron also prosecutes both Chinese and US trademarks. As he will demonstrate today, Aaron's knowledge of both the Chinese and American markets allow him to advise his clients as they expand their patent portfolios and look for investors to help the company grow. To submit questions today, please use the Q&A feature on the webinar menu. Thank you for joining us, and now over to Aaron.
Thank you very much for this introduction. So today we'll be talking about 10 things to know about the Chinese patent process. And we'll try to emphasize the differences between the US and Chinese patent process. So first filing and then prosecution. So briefly about myself, I'm the director of the China intellectual property practice here at Schwegman. I worked in China for 13 years. Where I was a registered foreign lawyer. I am also a US patent attorney, and I just returned from China about a year and a half ago. And this presentation is based on the article, 10 Things to Know About the Chinese Patent Process, that was in our blog, CNIPA.update.com. This was the most popular article over the last year or so on the blog, so I thought it'd be a good basis for this presentation. So first filing. Oh, and for those who are curious, this is a picture of Shanghai, specifically Lujiazui, which is right where I used to work. In fact, I can see my office building at the top of that park in the center there. So first, national phase entry deadline. So just like in the US, it is 30 months from your priority date to enter the national phase. But unlike the US, you can actually extend it for another 2 months with a minimal payment of 1,000 RMB, that's about $143. And this is a matter of right, it's automatic, and you don't need to file anything at 30 months. You just, at 32 months, with your national phase entry, you just pay this additional fee. So in that way, it's sort of similar to a US petition for extension of time. On the other hand, though, this deadline cannot be extended past 32 months, like in the US. In the US, you can show unintentional abandonment. There is no Chinese equivalent. In addition, your translation has to be provided at the time of filing and cannot be filed later as in the US. So if you give your Chinese counsel the application to file, say at 29 months, it's unlikely it'll be filed by 30 months because it can take a while to prepare that translation. So make sure you provide your application instructions early so they do have enough time to file by 30 months. Otherwise, they'll end up taking a 2-month extension. Reducing claim fees. So this is common in the US, but it doesn't work in China, unfortunately. Your claim fees are national phase entry are based on the number of claims published in the Patent Cooperation Treaty, the PCT application. So if you try to reduce the claims at filing, you still have to pay the claim fees for what was published. So what you can do, though, is file your PCT application with fewer claims. You only can get 10 for free, or 10 are included with the Chinese filing fee. And then, so list any deleted claims as examples in your specification, your detailed description or summary, and then add them back in later through a voluntary amendment, which we'll talk about because there's no additional claim fees for adding claims later. So, for example, if you have 50 claims in your PCT application, you only actually put down 10, and the 40 other claims are in your detailed description, and you add them in later as a voluntary amendment after filing in China, that would save you over $800 because each claim over 10 is 150 RMB, and about $21. Another difference is application type. So unlike the US, China offers both utility models and invention patents. So utility models offer significant advantages over invention patents, but the term of the deal is in exchange you get a much shorter term, half of the patent term you would get for invention patents. But the advantages are a quicker grant because there's no substantive examination, and it's harder to, or maybe harder to invalidate utility model versus invention patent because there's a lower bar for an inventive step. However, at national phase entry, you have to choose one or the other. You cannot do both, and you can't switch. So if you file a utility model and change your mind, you cannot do that. You're stuck with the utility model. So when should you choose a utility model? First consideration, it must be subject matter eligible. There are a lot of limitations that we'll talk about later on what's subject matter eligible, but generally for products, mechanical inventions, but not software, not pharma. Also, if you have low inventiveness in your application, for example, if your U.S. priority application is having a hard time going through the patent office, it doesn't look like it's going to grant, then you might want to consider filing a utility model in China instead of invention patent. Also, potentially, you might want to do a utility model and you need to enforce quickly. A utility model will probably grant within 6 months, at the most a year, and then pretty much you can enforce right away. So there's an infringer you need to enforce against, certainly consider doing a utility model. However, one thing you can do, and we'll talk more in the next section, is actually file both. But you have to do this at the 12-month priority date and not via PCT. So number 4 is filing this utility model and invention patent applications simultaneously in China. So for products, generally mechanical inventions, you can file both utility models and invention patent applications simultaneously by the 12-month date. They have to be filed all on the same day. Advantages, you get your quick protection via the utility model, usually 6 months to a year, while your invention patent is still pending, which can take 3 or 4 years sometimes. Also, another advantage is doing this gives you a fallback position if your invention patent never grants for whatever reason. You're having a hard time getting it through the patent office, you always have the utility model as a fallback. But there are limitations to this strategy. One is double patenting. You cannot have 2 patents for the same invention. So if the applications have the same scope, you have to abandon one or the other when the invention patent is going to grant. However, that's not always a problem because due to amendments during the invention patent application prosecution, the scopes are pretty different, so abandonment is not required. Also, there are no methods in the utility model, so your invention patent application will presumably have methods, so that will also give you different scope. If you do have to abandon, usually you want to keep the invention patent due to the longer term. It's 20 years for invention versus 10 years for the utility model. And much of the utility model term may have already passed because it does take several years to get your invention patent. So half your utility model term might already passed by the time your invention patent is ready to grant. Also, while the invention patent might have a narrower scope than the utility model due to the amendments you made, we might have a better chance of surviving invalidation because your invention patent has been substantively examined while your utility model has not been examined. In terms of subject matter eligibility, utility models are not for all inventions. They have a limited subject matter eligibility. They can only be granted for products which are objects manufactured by industrial methods having definite shape and structure, occupying a certain space. So some examples of what qualifies is, for example, a thermometer. Even though it may comprise mercury with a non-fixed shape, the mercury will go up or down inside the thermometer based on temperature, but the thermometer itself has a definite shape. Objects that have varying shapes, or only fixed shapes in specific circumstances, like a parachute. Only when that parachute is open is the shape fixed. That's still eligible. Engines, are also okay, even though they're moving parts. Fire extinguishers that might contain a gas within is also fine. Stents, medical devices, etc. Those are all eligible. What is not eligible are methods, chemicals or pharmaceuticals, software, so on. Also, in a utility model, you want to avoid filing an apparatus using functional claiming, because the examiner might reject that, just saying this is a method masquerading as an apparatus. Also note, even though there's not supposed to be substantive examination, the Chinese Patent Office is getting much stricter on utility models because there are a lot of junk utility models being filed. So if it appears to be a blatant copy of another application or another prior invention, you may get a substantive rejection even in a utility model. Semiconductors, integrated circuits, potentially can be, let's see. So we have a question. Can semiconductors, IC circuits, integrated circuits be protected by utility models? And yes, they can be potentially. So circuits I've seen where you actually specify, say, resistors, capacitors, and so on. That potentially could be protected by utility model. The method of operation or the method of manufacturing of a semiconductor integrated circuit cannot be, though. Also, again, with your circuit, you want to be careful with functional claiming, explaining what each element does in the circuit that may not fly with the utility model. In terms of fees for the utility model, the additional fees for filing utility models are minimal. You really should only have your foreign associate, your Chinese counsel's fee for formatting and filing the utility model. And then the actual patent office fees are also quite minimal, probably about $100 through grant. There should be no additional translation fee since the utility model uses the same translation as the invention patent application. Now moving on to prosecution. Voluntary amendments, adding new claims and claim fees. Generally, unlike the US, you can't amend on your own initiative whenever you want. You can only amend, such as adding new claims or just changing claims at these specific times. At initial filing, when filing a request for a substantive examination, that's due at 36 months from your priority date. And then after you file your request for substantive examination, you will receive notice of entering substantive examination. Usually that comes in 6 to 12 months after filing your request for substantive examination. You then have 3 months from that notice to amend. And as we mentioned before, there's no fee for adding claims during voluntary amendment after the initial filing. If you have a utility model, you can file the voluntary amendment within 2 months from the filing date, or date of entry of national phase. I recommend taking advantage of these voluntary amendments to make your Chinese claims match your US claims, your priority claims, because oftentimes I see the Chinese examiners, in addition to doing their own search and examination, they'll also look at the US office action, repeat rejections raised in there. So you might just end up wasting an office action instead of getting a really good examination. And this will just delay grant of your Chinese application. In addition, if you want to take advantage of the patent prosecution highway, you need claim correspondence in China. And if your claims don't match what ends up being allowed in the US, your PPH request might get rejected. Generally also, during prosecution, you're not going to be allowed to add claims in an office action response unless you're just splitting up a claim into 2 claims. Instead, what you end up with is examiner will just issue a new office action rejecting the added claims. That again is going to delay potential grant of your application. Of course, though, you can amend claims in response to rejections raised by examiners. Another thing to note in patent prosecution is we're very strict on antecedent basis. You have to recite terms exactly as you previously presented them. So if Bay's claim recites a metal film resistor, for example, the applicant has to recite in the dependent claims the metal film resistor instead of simply the resistor, even if there's only one resistor recited in the claims. I've seen examiners issue rejections, these formality rejections, just for things like this. Another thing that they're much stricter on than I've seen in the US is literal support. So even though in China, claims can be supported by not just what's literally in the application, but what can be reasonably derived from what's in the application, from the drawings and the specification. Nonetheless, examiners usually want literal support. They want you to copy exact text from the specification when you amend your claims. So if you're deleting quantifiers or adjectives, that may not fly. An example I've seen is if a claim recites 3 cylinders and you're trying to broaden that to plurality, or change it from 3 to at least 2, but your specification drawings show and recite 3 cylinders, the examiner will probably not allow that, even though arguably you could derive a plurality of cylinders from showing 3 cylinders. Also in preambles, I found a U.S. practice generally allows applicants to minimize your preambles and claims to things like a system or a method. Usually they require in China to recite the technical field in the preamble. So you may not be able to get away with a method, but you might be able to get away with a method of signal processing. Although on the other hand, sometimes they're much stricter in China and they'll actually require you to copy the title of your application into the claim preamble. Here's quite a big difference and something to be wary of is, unlike in the US, you cannot file divisionals of divisional applications. Divisionals are similar to continuations or divisionals. It's sort of a catch-all phrase. So basically, unlike the US, you cannot have a long chain of divisional applications. Generally, you have to file all your divisional applications while your original application is still pending. So when you get your notice of allowance in China, make sure to file every divisional application that you want or might need, because you're not going to have a chance later usually. The only exception is when you get a unity rejection in a divisional. So accordingly, if you really do want to keep a patent family pending, for example, you want to catch an infringer later on, wait till technology gets accepted and then craft claims to catch that infringer, you can try to force a unity rejection in the divisional by filing multiple independent claims with a different special technical feature in each claim. However, that's not guaranteed to work because the examiner may not agree with you that these really are worthy of a unity rejection. So it is a little bit risky. So again, the best thing is to file all the divisionals that you want for your first application grants. Also, number 10, use method of manufacturing claims. There's basically there's minimal discovery in China. On the other hand, though, if you use the methods of manufacturing new products, they'll actually switch the burden of proof to the defendant, because then the defendant has to prove that their manufacturing method is different than the patented method. The reason for this is that both your product and method must be new. So, in conclusion, be wary of updates to examination guidelines. There are constant updates. Just in the last couple of months, there were 2. These examination guidelines are similar to the manual of patent examining procedure, and some of these changes can be quite huge. So most recently, the ones I thought interesting was examiners have to prove common knowledge when challenged. This is similar to the U.S. Official notice. Before in office actions, you'd almost always see these common knowledge rejections. And the examiners tend to use them quite liberally without really good reason for it. And you're sort of out of luck. There was no way to really rebut that. But now you can actually tell the examiner, prove the common knowledge. Find a reference that shows this common knowledge. So I think that should make it much easier to get applications granted in China, or at least get more reasonable off-sanction rejections. Also, stem cell separated from human embryos within 14 days are now subject matter eligible. Also, for those that deal with software and particular business methods, will be a little bit easier to get these granted because now claims that include abstract features such as financial transactions have to be examined as a whole. You can't just focus on that one feature and then say that the whole claim is invalid. So that means technical problems, utilizing technical means and achieving technical effects. So if the other elements of the claim are not abstract, that might still mean the claim is subject matter eligible. Also, make sure to work with Chinese counsel. Due to the difference between U.S. and Chinese patent practices, especially in these formality issues, I recommend you allow the Chinese counsel to review and amend claims to comply with Chinese practice for these formality issues, such as we mentioned, like the preamble and antecedent basis, when you follow the response, or when you're doing a voluntary amendment. Also, I've noticed some Chinese counsel don't like to do this, and examiners aren't always receptive to this, but nonetheless, try to conduct telephone interviews with the examiners to clarify rejections and sound out proposed responses. When I was in China, we used to do this for almost every office action to find out if something would fly or not with the examiner, or to get some suggestions from the examiner. Usually the examiners were, at least receptive to listening to us. Sometimes they would tell you that you just need to follow the response and they'll think about it. Sometimes they were helpful. So it definitely doesn't hurt though to try. So in conclusion, I think by following these above strategies, you can smooth patent prosecution through the patent office. It will be much faster, smoother, you get a quicker grant. Also think about the patent prosecution highway to expedite examination. Also, as examination is not automatic, as it is in the US, consider requesting examination at filing to speed prosecution. The deadline is 36 months from your priority date, so they could significantly delay patent grant if you delay requesting examination. So now I'll open up if anybody has any questions. And also, this is the address for our blog, ChinaIPLawUpdate.com, where we have at least weekly updates on interesting cases, new laws, new regulations that come out in China. So if you do have any questions, please type it in the question and answer panel. Okay, I don't see any further questions. Thank you for attending. Really appreciate it. And feel free to contact us if you have any other questions. Thank you. Bye-bye. Oh, and if you email me, I can distribute the materials. awininger@slwip.com, AWININGER@slwip.com. Thank you.